Republican attorneys general are in court trying to take away your right to challenge unfair voting laws. Welcome back to Democracy Docket. I'm Marc Elias.
And I'm Paige Moskowitz. Let's get started. 23 of the country's 27 Republican attorneys generals are currently in court arguing that only the Justice Department, not voters, can file lawsuits to enforce Section 2 of the Voting Rights Act. Mark, explain to us why this argument is so dangerous.
You know, Paige, we talk a lot about how the Voting Rights Act was gutted in Shelby County versus Holder. What Shelby County did was it took away one of the big tools of the Voting Rights Act, but other tools in the Voting Rights Act remained. And so that's why you continue to see the litigation that's going forward around redistricting in states like Alabama and Louisiana and in Georgia, where groups and voters have brought cases saying that the maps that were passed in those states violate the rights of Black voters to not having their votes diluted in the creation of unfair maps. In plain English, in Alabama and Louisiana, the Republican legislatures drew maps with one Black opportunity district, and Black voters were able to bring lawsuits to say, hey, that's not fair to our community. You have drawn maps that prevent us from exercising political power. And in both of those states, the federal courts have agreed and have said that there needed to be a second Black opportunity district. Well, how are Republicans trying to gut this part of the Voting Rights Act and some others? By saying that private litigants can't even bring cases. They're saying that the only people who can enforce Section 2 of the Voting Rights Act and some other key provisions of federal law is the Department of Justice. That's crazy. That has never been the case. There has been the right of a private right of action, the ability of ordinary citizens who have been injured by these state laws, harmed by these illegal maps, to bring cases. And the overwhelming majority of Voting Rights Act cases that have been brought and have successfully vindicated the rights of minority voters to fair election laws, to fair maps, the overwhelming majority of those have been brought by private litigants, by organizations like the NAACP, by civil rights groups, by voting rights groups. It's what a lot of the work my law firm does is when we talk about representing Black voters in cases and winning relief, we're talking about bringing private litigation. Well, the Republican attorneys general are now latched onto a fringe argument where they want to gut the Voting Rights Act by basically taking away the ability of these private litigants to bring these cases.
Has this argument been successful anywhere in court so far? And if so, what has been the impact?
So they've had success one place, okay? Only one place so far in a case out of Arkansas that went up to the 8th Circuit Court of Appeals, which is the court that covers the state of Arkansas as well as some other states. And that circuit has said that they agree with this fringe argument, that they agree that there is no private right of action. But that's the only place they've had success so far. Now, they're pushing it elsewhere, but so far they have not had success. They've lost this argument in the 5th Circuit, which is critical because it's a very conservative circuit, but it also is a circuit that covers Texas. It's a circuit that covers Louisiana. It's a circuit that, that has a lot of Voting Rights Act cases within it, but they're pressing this argument all over the country. They're pressing this argument, for example, in the 11th Circuit. Now, anyone who thinks Brad Raffensperger is a hero, you got to read my article in Democracy Docket that how he's just another Republican vote suppressor. He is advocating this theory in a case out of Georgia to try to say that there is no private right of action. And while you're at it, make sure you are subscribed to Democracy Docket's free daily and weekly newsletter. The link is in the description below. You will get good, timely information about everything happening to democracy in court, and it is free. If you want premium content, you can also click in that link below and become a Democracy Docket member, at which point you will get premium content as well.
So if Republican officials are arguing that only the DOJ can file these lawsuits, has the Justice Department gotten involved? Have they said anything about these cases and these arguments?
Yeah, look, DOJ knows that they need the help. I mean, this is not a negative on DOJ, right? DOJ is doing as much work as it can do across a range of issues, and it's got its hands full, but it simply can't cover the territory that private litigants can. So DOJ agrees that there should be a private right of action. Again, that's not because DOJ is not up to the job, but of course, what's interesting, Paige, is that the Republicans don't want private right of actions, but do you think they want to provide more funding to DOJ to bring more claims under the Voting Rights Act? No, of course they don't. It's like, they don't want there to be private funding of election offices, but you don't see the Republicans trying to appropriate more money for our election officials to do their job. They want to starve democracy of money. They want to starve the Department of Justice of the resources to enforce the Voting Rights Act, and at the same time say that there's no private right of action so that private litigants can't bring these cases either.
These arguments are being made in the 5th, 6th, 7th, 8th, and 11th circuits. Don't worry, we have a map for you now of the circuits so you can see what states we're talking about. But Mark, is there anything special about these circuits? Why make the argument in these states?
Yeah, so what all of these circuits have in common is that they have a relatively high proportion of conservative judges. The Fifth Circuit, obviously well known as a very conservative circuit. The Sixth, the Seventh, the Eighth, also. When you look at the appointments, which president appointed them, which is not always the determiner, but you see that they are pretty conservative circuits. And the 11th Circuit also historically very conservative, becoming more balanced, but still leans in absolute numbers, leans more conservative. You'll note that these arguments have not been advanced in the First Circuit, the Second Circuit, the Third Circuit, the Fourth Circuit, in the DC circuits where the courts are tend to be more balanced or lean the other way. The Ninth Circuit, which covers California. So that's one thing that they all have in common. The other thing is that these are home to states that have traditionally had a lot of Section 2 cases brought, right? Particularly, you look at the Fifth Circuit, you look at the 11th Circuit, and what are you talking about now, Paige? You're talking about Florida, Georgia, Alabama, Louisiana, Mississippi, Texas, right? You're talking about states that have traditionally had a very, very large number of Section 2 cases brought because they represent much of the old Deep South. So, it is a conglomeration of, I think, where they think the courts would be most amenable to these arguments. It is a combination of where it would do the most damage to Black and Hispanic voters in particular. And of course, it's also where you have a lot of Republican attorneys general. Although, Paige, on that front, what's remarkable is you've got guys like the guy up in Ohio. I forget his name, the AG in Ohio.
Rokita.
Yeah, you'd think he'd have enough to do in Ohio, right? I mean, where they're constantly trying to muck up democracy. They tried to prevent the ballot initiative. Remember that, the ballot initiative for abortion access.
They have enough homegrown issues. They don't really need to bring this into federal courts.
Right, but yet, you see these states filing briefs, well outside of their own circuits, right? You see them; they're trying to mess around with these issues all over the place. But these are the places where I think they think that they can have the most success.
Mike, you hinted at this earlier, but voters have been suing to enforce Section 2 for decades. Why make the argument now that they can't file these lawsuits?
Because the Republican Party has become single-mindedly committed to election denialism. I mean, that's honestly the reason why. I just wrote a piece in Democracy Docket about the asymmetry of election denialism, and the one of the reasons why there is an asymmetry is because the only thing Republicans focus on right now is election denialism. And so while the Republican legal movement, 10 years ago or 5 years ago might have focused on antitrust law, might have focused on tax policy, right? They're dedicating all of their energies to figure out new ways to make it harder to vote and easier for Republicans to cheat. And so this is just a part of the making it harder to vote. They don't have any commitment to voting rights. In fact, they have a commitment to undermining voting rights and free and fair elections. So that's it. But also, they've lost all shame. It used to be shameful if you were a Republican to publicly oppose voting rights. It used to be a bipartisan, whether Republicans believed it or not, they voted to reauthorize the Voting Rights Act. But now the Republican Party has no shame, and it is proudly flying its flag of election denialism. And by the way, Paige, that flag may be upside down.
Mark, the big question in all of this is, how likely is it for the Supreme Court to get involved?
So that's obviously what the end game is on the other side, right? I mean, the end game on the other side is to try to get the Supreme Court to rule that there is no private right of action anywhere in the country under this law. And by the way, if they get it under Section 2 of the Voting Rights Act, they will extend that to various provisions of the Civil Rights Act and other parts of the federal protection for voting. So it doesn't end here. It sort of begins here, but they want to get the Supreme Court to take this case. Obviously, the easiest way for them to get the Supreme Court to take this case is to get a number of circuits ruling a variety of ways on this, because one of the reasons why the Supreme Court takes cases is to resolve what are called circuit splits. So if you got, 3 circuit courts of appeal saying yes and 3 circuit courts of appeal saying no, Supreme Court steps in to try to have there be a uniform ruling across the country. It's also, maybe catnip for some conservative justices on the Supreme Court who have been advocates for cutting back on voting rights, the reach of federal voting rights law. Remember, it was the Supreme Court that cut back Shelby County, did away with Section 5 of the Voting Rights Act. So it's something we all need to worry about. It's hard to say, will the Supreme Court take it and when would they take it? If they're not going to take it before the 2024 election, I don't think. But I think that, the other side's playing the long game on this. So it is, we have to prepare that at some point the Supreme Court may take this case. Now, let me say this, the Supreme Court has upheld a whole lot of cases or has ruled on a whole lot of cases that have come before it with private litigants in Section 2 claims. Just earlier this year, a few weeks ago, the Supreme Court, blocked a Louisiana effort to overrule a Section 2, essentially, in practical terms, overrule a Section 2 victory in Louisiana. We saw the U.S. Supreme Court affirm a Section 2 victory in Alabama just last year. So the Supreme Court would have to do a lot of fancy footwork to all of a sudden having, in dozens and dozens and dozens of cases in the last 60 years, affirmed, ruled in Section 2 cases without ever saying there was no private right of action. But then again, Paige, Dobbs, right? This is a Supreme Court that has shown itself able to, notwithstanding the long lineage of precedent and reliance on precedent, what a number of them in their confirmation hearings referred to Roe versus Wade as precedent upon precedent. I think one conservative justice called it. Another called it super precedent. So we can take nothing for granted. So we're all, this is yet another reason to make sure you are subscribed to Democracy Docket's daily and weekly newsletters. Thank you for watching this episode of Democracy Docket. And as I said, make sure you are subscribed in the links below.